Thus says the Lord, set your house in order, for you shall die and not live. Law Bob Radio. Law Bob Radio. Welcome to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman. Law Bob Radio. Bob has been practicing law for over 30 years and is certified by the State Bar of California as a legal specialist in estate planning, trust, and probate law. Bob is here to help you set your house in order with valuable insights you can use today to prepare a better tomorrow for your loved ones. And now, your host for Law Bob Radio, attorney Bob Bergman.
Hi, welcome to Law Bob Radio with your host, estate planning attorney Bob Bergman. I want to welcome you to the show today. Today I'm going to be talking about planning for your special needs child or other relative, and specifically the 10 costly mistakes to avoid when doing that planning. I'm going to be examining the unique planning requirements of families that have children, grandchildren, or other family members, such as parents, that have special needs. Now, there are many misconceptions in this area that result in costly mistakes in planning for these types of beneficiaries. And here are 10 of the most common costly mistakes that can be made when planning for beneficiaries with special needs. Now, the first one, which I hear fairly regularly with people coming into my office, is they express that they want to disinherit the child that has special needs because they want the child to be able to qualify for various types of government benefits. Now, many disabled people rely on SSI for their income, for Medicaid, which is called Medi-Cal in California, which covers their health care, or other government benefits to provide food and shelter, maybe such as Section 8 housing, for example. You may have been advised by otherwise well-meaning people to disinherit your disabled child, and the child who needs your help most, in order to protect their benefits. The fact is, these benefits rarely provide more than basic needs, and the solution of disinheriting your child does not help your disabled child after you become incapacitated or you've died. When a child requires or is likely to require governmental assistance, then you need to consider establishing a supplemental needs trust, a special trust for that special needs person. It's poor planning to disinherit a special needs person because a government program could be taken away at any time. What the government gives, the government can take away, and you could end up leaving that person with no resources to care for them, and that is obviously not a good plan. The second costly mistake is procrastination, because none of us really knows when we're going to die or when we might become incapacitated. It's important that you plan for a special needs beneficiary early on, just as you would plan for dependents such as minor children. However, unlike other beneficiaries or children who may grow up, a special needs child may never be able to compensate for a failure to plan. A minor beneficiary without special needs can obtain more resources as he or she reaches adulthood and can generally work to meet essential needs, but a special needs child may never have the ability to work. So please, there's unique planning challenges when it comes to planning for the special needs child. You simply cannot afford to wait to plan because you don't know at what point you may no longer be able to plan. The third costly mistake is the failure to coordinate a planning team effort. It's critical that as much as possible you have special needs planning be conducted with a team of advisors, an attorney such as myself who's experienced in this planning area, perhaps a life insurance agent who can provide life insurance products that will make sure there's enough money to maintain benefits for the special needs child, a CPA who can advise on any tax return that might be needed for a supplemental needs trust, an investment advisor for the trust who can assure that the fund's resources will last for the child's lifetime. And then there might also be a care manager or a care manager committee for the child who are there to kind of supervise and make sure the child's getting the care and the benefits that they need. The fourth costly mistake is to ignore that a child actually has special needs when you're planning for that child. Now, A lot of people don't want to admit that their child or their other relative or loved one is a special needs person. And I see this now and then. What that means is that if you don't plan for their special needs in mind and instead leave things directly to that person, what you're probably going to do is render them ineligible for essential government benefits. The problem is that special needs can include things like medical and dental expenses, independent checkups, necessary equipment for the person, like a specially equipped van for someone who's paraplegic, a van that has hand controls to drive it, training and education for the person, insurance for them, their transportation needs, and maybe special dietary needs as well. If you have sufficient funding in a trust for a person who's disabled, they can receive spending money, electronic equipment and appliances, computers, vacations, movies, money to pay for a companion, and other quality of life enhancing expenses could be paid from a trust like this. The sort of things that maybe you now provide to your child or the other special needs beneficiary in your life. So it's critical that you use a supplemental needs trust to pass assets on to the special needs person. Otherwise, if they have direct access to those monies, or if they have the right to decide or demand those monies, you may find that they're considered to be available assets, which will mean they're no longer eligible for those government benefit programs that are what we call needs-based. Needs-based meaning that you have to demonstrate that you have a financial need in order to receive that government benefit. Now, the fifth costly mistake that people can make is creating a generic supplemental needs trust that doesn't really fit the needs of the special needs person. Even some supplemental needs trusts are unnecessarily inflexible and they're generic in nature. An attorney with some knowledge of the area can protect almost any trust from invalidating a child's public benefits, but many trusts are not really customized to the particular child's needs. In other words, focused on the particular disability that the child is dealing with in his or her lifetime. Because of that, the child may fail to receive the benefits that you provided when you were alive. Another frequent mistake that can be made is a supplemental needs trust being drafted that includes a payback provision rather than allowing the remainder of the trust to go to others upon the death of the special needs child. Payback provisions are generally required when someone receives an inheritance or a distribution of money or a gift and they're a special needs person. They will generally have to go to court in order to have a special needs trust established for them with their own property. This is called a first-party special needs trust, in that the person whose property it is the beneficiary of the trust that's created. Those trusts are required to have a payback provision, meaning that when that person dies, the assets in the trust have first to be used to pay back any government benefits that were received during the lifetime of that person. A third-party trust, which is a trust that's established by a third party, such as a parent, a sibling, a grandparent, or even a friend, and then assets are put in for that special needs person that come from that third party and others. Those types of trusts do not have to have a payback provision, which is crucial. It means that when the special needs person passes away, their trust is not going to have to pay back the various government benefits that were received during that person's lifetime. So, make sure you use an attorney that knows the difference between a pure special needs trust and a supplemental needs trust, because the difference could be the difference in the family losing thousands or potentially even hundreds of thousands of dollars when the special needs person passes away. The sixth costly mistake is the failure to properly fund and maintain the plan. Now, let me explain what I mean by fund or funding. To fund a trust means to transfer the ownership or title of assets into the trust. You can fund trust with all kinds of assets. It could have real estate. It could have cash, stocks, bonds, mutual funds, annuities. There could be life insurance that's funded in the trust and is designed to actually pay the death benefit into the trust when the person who's insured actually passes away. In many instances, you want to actually use something like life insurance that's going to ensure liquidity for that supplemental needs trust when it's needed. It may not be needed while you're alive, but it may very well be needed when you pass away. So life insurance can be a very, very effective way to put a large sum of money into a trust to take care of that special needs person after you're gone. And oftentimes the best insurance is what we call permanent life insurance, meaning life insurance that's intended to last for your entire life. It tends to be more expensive, but it also is going to be there when you pass away, so that it's there to take care for the special needs person. Now, after the break, I'm going to come back and talk about another 4 costly mistakes that people make in planning for their special needs child. And then at the end of the show, I'm going to do a recap of all of these and urge you that if you have a special needs person in your life, take the steps now to plan for them. So after the break, I'll be coming back. For Law Bob Radio, this is Bob Bergman. Talk to you after the break.
For questions or comments, send email to lawbobradio@gmail.com. That's LAWBOB radio@gmail.com. Now back to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman.
Welcome back to Law Bob Radio, where I've been talking about the 10 costly mistakes to avoid when planning for your special needs child. Before the break, I talked about using life insurance to provide funding for a supplemental needs trust for your special needs child. That can often be done through another type of estate planning tool called the ILIT, or Irrevocable Life Insurance Trust. This will be a trust that can own life insurance outside of your estate, which has the advantage of having it also not be subject to your creditors when you die, because you didn't actually own the insurance. The trust owns the insurance, and the trust in turn would name your child's supplemental needs trust as the beneficiary of the insurance trust. As an alternative, if you don't have an estate tax situation or you're not worried about creditors, you might consider naming your own revocable living trust as the beneficiary of the life insurance, which would enable you to equalize inheritances between your special needs child and your other children, if that is an objective that you might have. The 7th costly mistake: choosing the wrong trustee for the supplemental needs trust. Now, during your lifetime, you can manage your child's supplemental needs trust. In fact, you can set up a trust like this. You can start making contributions to it right now. You can even have other family members or friends make contributions to it right now. But when you're no longer able to serve as the trustee because you've become incapacitated or you've passed away, you can decide who will serve as the trustee of the supplemental needs trust according to the instructions that you provided in the trust document itself. You may also decide that you want a team of advisors involved, such as the care manager or care manager committee, or a professional trustee. Whomever you choose, it's crucial that the trustee be financially savvy, well organized, and, of course, ethical. I think it's actually more important to have a trustee that is ethical and honest, maybe not financially savvy, but is willing to go hire people who are, and someone who's well organized than pretty much anything else. With the supplemental needs trust, you can also put in place someone called a trust protector or a trust advisory committee, which can be an individual or a group of people that are given the power to actually have oversight over the trustee of that supplemental needs trust. In fact, in my practice, I insist that my clients either come up with people that they would want to have that oversight, or at the very least, that they give a mechanism in the trust for a trust protector to be appointed by someone or appointed by a court so that you have an independent third party that's looking over the shoulder of the trustee to make sure that they're doing a good job for your child or your other relative who's special needs. The eighth costly mistake is failing to invite contributions from others to the trust that you've set up for your child. I already mentioned that with a supplemental needs trust, people other than yourself can make contributions to it. A key benefit of creating a trust like this now is that your special needs child's extended family and friends can make gifts to the trust or remember the supplemental needs trust as they plan their own estates. For example, these family members and friends can name the supplemental needs trust as the beneficiary of assets from their revocable trust or will. They could also name the supplemental needs trust as a beneficiary of life insurance or retirement plan benefits. So creating a supplemental needs trust now allows others, especially such as grandparents and other family members, to name the trust as a beneficiary of their own planning or to make contributions now. This is especially important. It's especially important that extended family and friends know that you have a trust like this set up for your child. One of the things that happens fairly regularly and is a real problem is that a family member, especially a grandparent, leaves a sum of money to a special needs grandchild or niece or nephew, whatever it happens to be, because they want to, quote, help out when they've died. The problem is leaving the money directly to that special needs person means they've now received assets. It will cause a loss of benefits that are needs-based, such as SSI, Medi-Cal for health insurance, maybe even Section 8 housing where they're living. Could also mean they get kicked out of a program that is set up for someone with that specific type of disability because they now have assets and they have to have no or very few assets in order to qualify for the program. So please, if you set up a trust like this, let family and friends know that if they want to help out, they need to direct assets to go into that trust and not directly to the special needs person. Mistake number 9, and this is a big one, relying on your special needs child's siblings, your other children, to use their money for your special needs child's benefit. A lot of people will say, well, I'm not going to leave anything to my child. I'm going to leave everything to my other children with instructions that they take care of their brother, take care of their sister, whatever it happens to be. So you're now relying on your other children to provide for the needs of your special needs child from their own inheritances. Now, this can be a temporary solution for a brief time, such as during your brief incapacity if your other children are financially secure and have money to spare, but it's not a solution that will protect your special needs child after you've died or when your special needs child's siblings have their own children, their own expenses, and their own financial priorities. What if the child you leave the property to gets a divorce or loses a lawsuit? His or her spouse or a judgment creditor may be entitled to half of the property in divorce, or maybe will take the property entirely because of a judgment, and they're likely not going to care for your special needs child. What if that person dies or becomes incapacitated while your special needs child is still alive? Will the siblings care for your special needs child as thoughtfully and completely as the sibling did? In other words, will their children care for your child in the same way? Siblings of a special needs child often feel a great responsibility for that child and have felt so all their lives. When you provide clear instructions and a helpful structure how to help, this lessens the burden on all of your children and supports a loving and helpful and involved relationship among them. So, using the special or supplemental needs trust is the way to go. You can have the children, your other children, be in charge of it as trustees, or they can be involved as care managers, any number of things in there. The 10th mistake, and this is one that I've seen in my own extended family and my wife's family, is the failure to protect the special needs child from predators. Now, an inheritance that goes from you into a child's supplemental needs trust by a will is in the public record. Predators are particularly attracted to vulnerable beneficiaries, such as those who are too young and those with limited ability to protect themselves. When you plan with trusts rather than a will, you decide who has access to the information about your children's inheritance rather than the probate court system deciding. This would protect your special needs child and other family members who may be serving as trustees from predators. This is because distributions from a living trust to a supplemental needs trust are generally handled through the attorney's office and not handled publicly, which means there is no public information to trace the fact that money went into a trust like that. You also want to make sure that with a supplemental needs trust, the special needs person that's being protected by him does not have any kind of direct access to the property in there, because with direct access, they could be preyed upon by a predator that is trying to get access to the monies that they have in their trust. Now, in conclusion, planning for special needs beneficiaries requires proper care and the participation of all of the wealth planning advisors involved: the attorney, the CPA, the financial advisor, perhaps care managers as well, the trustee, especially the successor trustee. A properly drafted and funded supplemental needs trust can ensure that your special needs child has sufficient assets to care for him or her in a manner intended by you throughout the beneficiary's lifetime. So let's do a quick recap for the 10 mistakes. You want to make sure you don't disinherit your child. You don't want to procrastinate. You don't want to avoid having a planning team effort. You don't want to ignore the special needs when planning for the child. You don't want to create a generic supplemental needs trust. You want to properly fund and maintain the plan. You want to choose the right trustee. You want to invite contributions from the trust. You don't want to rely on your children to take and use their own money to take care of your special needs child. And you want to protect the special needs child from predators. If you have a special needs child, I urge you to consider making an appointment to meet with me. You can go to my website at lawbob.com and book a consultation with me. There's no charge. So until next time, this is estate planning attorney Bob Bergman for Law Bob Radio. Goodbye.
You've been listening to Law Bob Radio with estate planning attorney Bob Bergman. Bob gives regular seminars on estate planning and is available to do estate planning presentations for churches and other community groups. For more information or to schedule a consultation, visit lawbob.com, lawbob.com, or call his office in San Jose, 408-247-0444. That's 408-247-0444.
Opinions expressed are for informational purposes only and should not be construed to be legal, financial, or tax advice. Seek appropriate legal advice regarding your particular situation. Attorney Bob Bergman does not offer any guarantees with regard to the outcome of your legal matter. Prior results in other cases do not guarantee a similar outcome in your case. All rights reserved.